Good morning, good afternoon, and good evening to you, depending on where you are watching from. We are here to intimate you again why Tinubu cannot get there. Yes, there is a particular, should I say, blunder by INEC that will restrain Tinubu. You will hear from a former CGN of Nigeria. But before you hear from him, let me tell you what it's all about. Then we will read also what another legal luminary, retired, said about this. It is important you know. Tinubu did not make it. Tinubu did not win. First of all, this 25% that you need to get in Abuja as among, one of the criteria. On the normal day, INEC is not supposed to announce Tinubu as, winner of the election. INEC does not have the right to announce Tinubu unless the Constitution approves of that. The Constitution says this and that. INEC did not follow. Maybe it skipped the mind of Yakubu, or he deliberately, they couldn't manipulate Abuja, and they forgot that you need to get 25% in Abuja. So he didn't meet that requirement, and INEC went further to announce him. And that was among the things P2B wants INEC to come and prove how Tinubu won. Now let's read what Dele Farotimi said about this. Then I will take you to what a former CGN said that will amaze you. Remember, our discussion is still on that FCT, Capital Territory. Yes, which has brought about so much heated debates. He failed to secure 25% of votes in FCT, despite the claim that he won the 2023 presidential election. While some argue that the FCT significance is negligible if the candidate obtains 25% in at least 24 states, which Dele Farotimi is beginning to deflect. He said the Constitution clearly defines the criteria for declaring a candidate as the winner of presidential election. So INEC has to also abide by that Constitution. According to him, a candidate must secure, and we already know, 25% of the votes in 24 states, including FCT and FCT. He further emphasized that the court's response to this matter will have a significant impact on the future effectiveness of the FCT in forthcoming election. This case is also in the Supreme Court. I think the judgment is supposed to be passed Friday. And whatever will be the outcome of that judgment will affect future elections in Nigeria. If they say Abuja is not really necessary, then from this time onwards, people do not need to win Abuja. But we are talking about what Constitution clearly specifies now. Now, he also added, he said the entire votes of Asiwaju in 5 Southeast states was 500,000, just 500,000, and it is less than 10%. There is a constitutional provision for determining the elected president, requiring 25% in states, including the FCT. According to Dele Farotimi, he didn't write that. It is clear for everyone to see. You all are aware, or even those who are saying Tinubu won the election, everybody, they are aware that he didn't win FCT as specified. And no wonder they issued him certificate at night. And they gave it to him at night. Meanwhile, now, let's go to what a former CGN and Dwaka said. Because, May 29, for you people who are saying, he's already there, he's in the defense house, you might be shocked with Friday's judgment. This is somebody who is very learned in the law. You need to listen to what he said.
What's your thoughts on that?
Well, thank you very much. I have spoken so much about this and I wouldn't want to be personal. But I wish to draw the attention to the reading of a document, the requirement of a law. The Constitution is a document, and for you to get the true intention of a particular provision of the Constitution, for instance, Section 134, subsection 2, you have to read the entire Constitution in reference to other provisions of the Constitution. That is where you will get the true meaning. Today, I don't want to specifically talk about Section 134, subsection 2, but to give you other background provisions that if you want to construe that provision, you must also have to look at them to give you what you are looking for. First, let's look at the Constitution itself, Section 1 and 2. And Section 1 said Nigeria should be a federation consisting of the state and the federal capital. That is the beginning. Should be a federation consisting of states and federal capital. That and appeared there. If you go back to the sections, Section 3 of the Constitution, it went ahead to list the 36 states of the federation by name. From there up to Section 6 of the Constitution, you will discover that what is local government is specified, what is area council is specified, the area of the states are defined in the schedule, the area of the federal capital territory is defined in the schedule. So you will know that there's no mix up of what is federal capital or what is state, because they are specifically mentioned, and the rules of interpretation is that what is specifically mentioned in the Constitution or in a document, what is not mentioned is excluded. So if you look at it, the states are well defined, their territorial area well defined, even their capitals are well defined. If you come to the issue of the federal local governments contained in all the states, well defined, and then the Constitution not pretend in federal capital to say they have a local government, say they have 6 area councils, specifically defined in the second schedule of what is the federal capital. Then if you go back to Section 133B of the Constitution, which deals with presidential election, which comes before Section 134, you will see that a person who is a single candidate at the election is still stipulated to win 25% in 2/3 of all the states and federal capital. And it goes to say that if somebody is not elected in accordance with the Constitution, fresh nomination should be. That one has gone further, not talk of fresh election, say fresh nomination should be taken. That is how serious it is. If you marry that provisions, you'll be able to arrive at the true intention of Section 134, subsection 2. You must look at Section 133. Because the person is just a single candidate, yet the stipulations say you must get 2/3 of yes or no in the 2/3 of the 36 states of the Federation and federal capital. And if he is not elected, there's no winner in accordance with the provisions of Section 133, fresh nomination, not election, fresh nomination should be conducted. That is the case of a single candidate. So when you come to 134, which deals with multiple candidates, 2 or more candidates, the procedure is almost the same. The ant came again. Where it's being argued, maybe rightly or wrongly, that Section 299 makes the federal capital a state. I'm afraid where something is specifically mentioned, well defined, I don't think importation of that kind of interpretation may be appropriate. But that is still left to be resolved by the aspect. But assuming you now look at that 299 and equate it, you will see the special nature of the federal character, because there is also specified that the president should act as if he's a governor. And therefore, one may be tempted as the federal capital is created, given a special nature. And if you look at it literally, if he's deemed to be a governor, Section 176 of Section 2 of the requirements of winning 2/3 must have applied. But here the Constitution stipulated it should only be 25%. I thought that is the more proper constitution to consideration. Because if you are saying it's a state, then the issue of requirements of winning to the federal capital by 2/3 as specified in the governorship election will arise. But I don't think that's what is the import of the constitution. But so much has been said, has been repeated about this. I just drew the attention to the other sections of the constitution that can give more light, because the interpretation rules say make reference to other relevant provisions of the constitution for clarity. And again says you should read the whole documents as a whole. Section 299 appear to be more consonant with the administrative procedure, which gives the state, the federal capital, the power to the president as if he's a governor to administer the federal capital, and the National Assembly as if it's a House of Assembly to make laws for the federal capital. That is my understanding of it. But it has generated so much and it's important. I'm afraid we'll see.
Hello, great people. Have you heard that? I want to thank Andoaka. I think he's the former Minister of Justice. Maybe not CGN, as I said. Yeah. Oh, what a nice take on this particular matter. And I wonder how the tribunal will settle this. Because, he so much broke it down in a way the layman will understand it. Let's go to what he said, and shortly on that we will leave. Requirements of the law. He mentioned section 134. The Nigeria should be a federation consisting of state and federal capital. And the constitution has specified what is what. There's nothing like mixing up. We know what is a state in Nigeria. We know what our local government, according to what it said. And we know federal capital, which is like having a special status. That is what he said. So everything is clearly defined. Now he said, now section 133b, where he said the requirement, the specified requirement for someone to be declared president in this country, he has to win 25% in 2/3 of the states, and federal capital has to win 2/3 of the states are 24 of states. There are 36 states. Then, and federal capital. It is so clear, there is no mincing of words about that. People can decide to lie and lie whatsoever, but it is so clear, well specified. When 2/3 of the state, which is 25%, you have to get 25% in 2/3 of the state, and FCT. And he said, in a case whereby the person did not meet this requirement, he's not even talking about fresh election. No, he said fresh nomination. So I see a case of disqualification. Fresh nomination, not even fresh. I don't know whether they are seeing it the way he saw it. And again, I like the next point. He said, the president should be seen as the governor of Abuja. Yes. Abuja has almost all that other states have. In the state, we have State House of Assembly, the legislature. Abuja has the General House, the Senate, and the Reps, which is more, due to it's governing the country. It depends on how you look at it. You have to win 25% in 24 states, and Abuja, just like WAEC, you have to score 5 credits or so number of credits. Must include, depend on the course you are pursuing, English or maths, or English and maths. So he's reading everything as a whole. Abuja has, if you are not accepted, you are going to, the president is like the governor of Abuja. That is why there's no election for Abuja, as in state election. The election that is done for Abuja, apart from the House of Senate and the other ones, the election that is done at the national level, that of presidency. So, as a president of Nigeria, you are like the governor of Abuja. You have to win at least 25% in Abuja. Tinubu did not get that 25%. So on what basis did INEC find it right to declare Tinubu president. And this is, I know they are taking what he said, or they have taken it into consideration. I like the way Andoaka, and imagine Andoaka was in charge, or is in charge right now, how this judgment would have gone without any interference. Viewers, what do you think? Add your comment on the comment section. If you have to be the governor of Abuja, you have to win at least 25% in Abuja. He didn't win up to that. And I'm sure, and I perceive that he may not have gotten 25% in other states that was given to him. Viewers, what do you think? Add your comment on the comment section. Please subscribe to our YouTube channel if you have not subscribed. Follow us on Facebook, Twitter, and Instagram for more updates. Bye-bye for now.